Okay, I can still see people coming in, but we'll make a start. So hello to you, wherever you are in the world. My name is Andrew Mackenzie. I'm Chief Executive of the Scottish Arbitration Centre, and I'm delighted that the Centre is hosting this webinar tonight at IBA Virtually Together. I'm not quite so delighted not to be in Miami, where the IBA annual conference was meant to be taking place, but hosting this Scotland night at the IBA is going some way to make up for that. Some Scots out there, particularly football fans, might have thought that last night was Scotland's night. Yes, with our qualifying for the finals of Euro 2020. Scotland in Europe again. But actually, this is Scotland night at the IBA, and indeed our First Minister, Nicola Sturgeon, will be taking to the IBA Virtually Together stage in just under 1 hour. It might be suggested that we are simply the warm-up to Nicola Sturgeon, but let me tell you, that is not the case. So with the International Council for Commercial Arbitration, that's ICCA, and their Congress destined for Edinburgh next year, Scotland has been in the spotlight in terms of international arbitration. This webinar will explore the reasons behind that focus on Scotland, consider Scotland's legal and arbitration system within the wider UK, discuss dispute resolution in Scotland, including the court's approach to arbitration and mediation, and share expertise on operating in this and other jurisdictions. We have a very distinguished panel tonight, and Brandon Malone. No, joking, Brandon, he knows I'm joking. I'm delighted that Lucy Reid and our Lord President have joined us, and I'll introduce each speaker properly in turn, but then the plan is we'll hear from them now, and then we'll have 15 minutes Q&A at the end. So please submit your questions for the speakers in the Q&A section at the bottom of your screen. And my colleague Fiona Mingus and I will monitor these throughout and put as many as we can to the panel later on. Please also post comments. I can already see some comments coming in. Let us know who's out there. Let us know where you are in the world. But please don't put any questions on there. Save the questions for the Q&A box. So it's Scotland night, it's Friday night. So pour yourself a whiskey or maybe a Scottish gin, sit back and enjoy our webinar. So our first speaker tonight is Lucy Reid. She needs little introduction as a well-known arbitrator now at Arbitration Chambers based in New York. She's also one of 2 vice presidents of the Singapore International Arbitration Centre Court and a member of the US Council on Foreign Relations. Until last year, Lucy was director of the Centre for International Law and professor of practice on the Faculty of Law of the National University of Singapore, and was previously a partner at Freshfields working in Singapore, Hong Kong, and New York. She's also an editor of the Oxford International Arbitration Series and has served on the editorial boards of the Journal of International Arbitration and the ICCA Review. Crucially though, Lucy is the president of the International Council for Commercial Arbitration, that's ICCA, which will hold its prestigious Congress in Edinburgh next year. Lucy is going to talk about ICCA and its approach to selecting jurisdictions to host its Congress. Lucy.
Thank you, Andrew and Brandon. And I have accomplished many things in my career, it's true, but I have yet to visit Scotland. So I'm determined to make it happen. I have a few slides for you, so let me share my screen. All right, I have to make this bigger. Sorry. Uh-oh. Uh-oh, are you still there? All right. Screen sharing.
We're still here.
I've lost my screen sharing. Okay, here we go. Can you see the slide?
Yep.
Full size. That's what I'm trying to do.
Yeah, that's it now.
Okay, that's good enough. All right. As president of ICCA, again, I want to thank you for inviting me. ICCA has very close links with Scotland over the years, and they're continuing as we get ready for the Congress next September 2021. Let me just say a few things for those of you who don't know the background of ICCA. It's not a very good acronym, I know. It's the International Council for Commercial Arbitration. ICCA was founded back in 1961. It's a worldwide membership organization that's devoted to promoting and developing international arbitration and other forms of international dispute resolution. It fulfills its mission in several ways. First, ICCA started historically as a publisher on international arbitration and is now probably the leader in that field. We're best known for our yearbook, our handbooks, and our Congress proceedings. We publish with Kluwer. Second, we initiate and collaborate on various research projects. You'll be particularly interested, I think, in our working group on cybersecurity in international arbitration, which is very much front burner, and it's chaired by none other than your own Brandon Malone. The group has already published a cybersecurity protocol for international arbitration, which is, I think, mandatory reading for those of us who sit as arbitrator or as counsel. And that will be the focus of much discussion at the Edinburgh Congress. We've also started, just now we've started a new project, which is a comparative review of the right to a physical in-person hearing versus a virtual hearing in approximately 80 jurisdictions. And we're hoping to publish comparative data by the end of the year. There's a big demand for that, as you can imagine, right now. Third, ICCA offers judicial workshops on interpretation and application of the New York Convention, known as New York Convention Roadshows. We've done about 30, but a highlight was the one with the senators of the College of Justice in real Edinburgh, not virtual Edinburgh, in collaboration with the center last year. Fourth, we support this is a picture of the Roadshow in Scotland. Fourth, we support a branch for young practitioners, which has over 7,000 members. And this is a good opportunity for me to thank the center for hosting and sponsoring a very successful Young ICCA skills workshop that we did in 2019 on cross-examination. Now, finally, what I would call the crown jewel of ICCA is its biannual Congress. Since 1961, the ICCA Congress, and this sounds like a boast, but I think it's true, the ICCA Congress is the largest regular gathering on the international arbitration calendar, attracting up to 1,000 leading experts and newcomers alike. And each Congress gives the host jurisdiction the platform to demonstrate to a global audience its existing and potential contributions to international arbitration, which we will be seeing in Scotland next year. Now, I want to back up a few years, in fact, more than a few years, back to 2016 at the Mauritius Congress, which is when the center submitted its formal final bid to host the Congress in 2020 in Edinburgh. Of course, now it's 2021, thanks to COVID-19. There was a long list of bidders, and no one who was there in Mauritius will forget the sight of Andrew and Brandon Natalie kilted entering the governing board meeting behind a lone piper. But as the inaugural chair of the Congress Committee and the lead drafter of the bidding and selection rules, I can tell you that a lot had happened before that dramatic Scottish moment. First, there's a pre-bidding process and review by the Congress Committee. Then the final bidders are invited to make a presentation in addition to the written presentation to the governing board in person at the Congress, after which the governing board evaluates the bids against a long list of criteria. These include concrete support from the local international arbitration community, council, and the judiciary, conference venues and infrastructure, logistics, geographic diversity, and in many ways, most important, the benefits that are likely to accrue to the jurisdiction and the region and the global practice of international arbitration. I think it was in our Singapore host from 2012 who said that the Congress creates true recognition of the host jurisdiction as a venue for international arbitration. But as much as the Congress may boost the practice and the attraction of the host jurisdiction, the fact is everyone who comes takes away new ideas to use at home. Now, going back to the 2016 bid, I recall very well that Brandon emphasized that the Center has promoted arbitration in Scotland since 2011, and very quickly in 2015 had already garnered a nomination for Global Arbitration Review's up-and-coming Regional Arbitration Institution of the Year. In addition to highlighting the unique blend of common and civil legal traditions in Scotland, of which you'll hear much more from the Lord President in a few minutes, the bid emphasized that Scotland is the EU's largest oil producer and a hub for renewables, thereby connecting the center to energy arbitration, which is a leading sector for us. And finally, I would be remiss not to mention that your prospective hosts with the Edinburgh tartan, which you can see on the screen, readily convinced us that Edinburgh would live up to its legendary reputation for hospitality. So here we are. Well, let me back up a little bit. In 2018, after the Sydney Congress, Brandon encouraged us to look to Scotland, and I quote, to take part in the blossoming of a new Scottish Enlightenment. Appropriately, the program committee for the Congress has selected the theme, Arbitration's Age of Enlightenment. We at ICCA look forward to the enlightenment that is bound to come next year when Scottish practitioners meet up with practitioners from, well, really just about everywhere to share their international arbitration expertise and learn from each other. So on behalf of ICCA, I want to thank you, Brandon, Andrew, everyone at the Center for your extraordinary flexibility in rescheduling the Congress twice because of COVID-19, but I am confident that with the new dates in September 2021, we will be able to meet in person. It will be the first meeting in person for many of us, and hence is even more anticipated than it would be otherwise. So thank you for that. I finish.
Thanks very much, Lucy. That's a great introduction and explanation for ICCA's involvement in Scotland at the moment. Our next speaker is Lord Carloway. Lord Carloway is the Lord President of the Court of Session, so the head of Scotland's judiciary, and has held the position since 2016. He was previously Lord Justice Clerk and has been a judge for 20 years. A graduate of Edinburgh University, he was admitted to the Scottish Bar in 1977 and appointed as Queen's Counsel in 1990. He's also a former president of the Scottish Arts Club. Most importantly, he's been a good friend to the Scottish Arbitration Centre, speaking at previous centre events and supporting our hosting of ICCA Edinburgh. Lord Carloway is going to discuss Scotland's separate legal and court system within the UK and our approach to dispute resolution. Lord Carloway.
Thank you, and thank you for inviting me to address this session. The context for what I'll be talking about is Scotland's unique constitutional framework, which some of our international audience may not be too familiar with. After it joined England and Wales by the Treaty of Union in 1707, Scotland retained its own separate legal jurisdiction and independent court system. It was specifically provided in the treaty that the Court of Session, which is Scotland's supreme civil court, should continue. Private law was not to be altered except for the evident utility of the subjects within Scotland. As a result of a quirk in the drafting of the treaty, civil appeals did manage to escape across the border to the House of Lords in London. But when dealing with cases from Scotland, that court and its successor, the UK Supreme Court, applies Scots law and not just any kind of federal or British law. Traditionally, two of the justices in the UK court are Scots lawyers, and coincidentally, they happen to be the President and the Deputy President today. Historically, Scots private law derived from a blend of Roman law and local custom. After the union with England, it remained and remains a mixed system. In the classical age of Scots law, which coincided with the Enlightenment of the 18th century, our commercial law was, I quote, an emanation of the lex mercatoria, or law merchant, and a system of principles which transcended national jurisdictions. Despite our proximity, or perhaps because of it, our constitutional arrangements and our system generally is not at its foundations Anglo-American common law, although as an adversarial rather than inquisitorial system, many aspects of its civil procedures are very similar to those used in countries which do adopt the Anglo-American system. As we see it, the advantages of the Scots system is that it's a body of law which is drawn from each of the two major European legal traditions. It uses a method of legal reasoning which relies on consolidated principle rather than formal precedent, even if in most cases the outcome may be the same. In the post-Union era, because of the absence of a legislature which was specifically tasked with the development of Scots law, its substance and its rules of evidence and procedure were for some years, and in many respects, preserved in aspect rather than modernised. The establishment in 1965 of the Scottish Law Commission, which was responsible for keeping the law under review and facilitating its improvement and simplification, did help. Nevertheless, by the end of the pre-devolution era, some of the more esoteric parts of our laws, as with many other legal systems, might have been described as not only unique, but also as quaint. In the post-devolution era, although there are remnants of the antique still present in a few areas, the inertia of the past has been largely reversed. In 1999, the Scottish Parliament sat for the first time in almost 300 years. Having the political branches of the state closer to home since then has proved advantageous. There is a strong degree of mutual respect for the constitutional essentials, the separation of power and the rule of law. There is certainly no room for complacency, especially in the current global climate. There are areas of potential conflict, including current proposals for the regulation of the legal profession. But the Scottish Parliament and successive Scottish governments have generally been eager to preserve and enhance judicial independence. By and large, Scottish politicians, and certainly the senior officials, are acutely conscious of the importance of the rule of law. The new Parliament addressed, to an extent, the problem of a lack of legislative time, which was dedicated to the reform and modernisation of Scots law and the legal system, over which the Parliament has legislative competence. In terms of the process of dispute resolution, the major reform has been the legislation which followed a comprehensive review of the whole Scottish civil justice system conducted by my predecessor as Lord President, Lord Gill. Proportionality of resource and efficiency were at the centre of this, and these principles have become the cornerstones of modern Scottish civil justice. The central idea is that cases should be dealt with at an appropriate judicial level using proportionate judicial time and expense. Appeals should generally require leave. Low-value cases with poor prospects of success should not be permitted to fester for prolonged periods at superior court level. The changes were radical. They involved the setting up of two new courts, an intermediate appeal court below the Court of Session, and a new personal injury court. A third tier of judiciary, which would deal with low-value civil cases, was introduced. Many of the Law Commission's proposals for the reform of the substantive law have been implemented since devolution. These have included major changes to land law, succession and bankruptcy, and certain special aspects of contract law. A legislature in Edinburgh has improved engagement between the senior judiciary and government ministers. This has instigated and quickened necessary reforms to both procedure and institutions. One of the most significant has been the creation of the Scottish Courts and Tribunal Service as an agency independent of government and charged with supporting the judiciary. The SCTS has given substantial flexibility in tailoring the system, having exclusive control of its building, staff and systems, and being judicially led. The total budget is agreed with the Scottish Government, and the SCTS is then able to direct expenditure in accordance with the priorities as the SCTS board perceives them to be. The Scottish Civil Justice Council, which was established in 2013, is also judicially led and provides the key institutional basis for the constant evolution of the civil dispute resolution system. The members of the Council and its subcommittees are experienced practitioners, judicial office holders, and administrative staff. They can quickly identify reform needs as they arise, and if they do, they can ask my office to draft the necessary amendments to the court rules. For example, it was the Council which generated the long overdue new rules governing group proceedings, otherwise known as class actions. One of the statutory principles guiding the Council's work is that methods of resolving disputes which do not involve the courts should be promoted. In all of this, I do not pretend that everything in the system is rosy. It is not, especially in these difficult times. The essential structures are there, but with the enormous leaps in the technological systems which we have, and which I suspect all of us have experienced over the last few months, the future will be bright if appropriate funding is in place. Within Scotland's Superior Court of Session, there is a dedicated commercial division. I should explain that the Court of Session is a unitary court which deals with cases at first instance if they have a value of excess of £100,000, but it also has two appellate divisions within the same complex. The Commercial Court offers an attractive forum for those engaged in 21st century technologically driven commercial life. At any one time, there are 4 judges permanently allocated to the Commercial Court, and more commercially experienced judges can be and are allocated to substantive hearings in that court as required. It's not London, New York, Hong Kong, or Singapore, but it is an available, user-friendly, and relatively cost-effective option, especially for cases with a UK component. One of the main aims is to ensure that all commercial cases are decided at first instance by a judge who has had substantial practical experience in financial and commercial matters, both on the bench and before that at the bar. Several of our inferior courts, which are known as the sheriff courts, also have specialist commercial divisions dealing particularly, although not exclusively, with claims below the £100,000 mark. The overall aim is, and I quote, to provide an ecosystem which encourages and enables resolution by the parties even once a commercial case is up and running. Pre-action discussion, simplified pleadings, and active judicial case management are all important features. The court accommodates pragmatism in pursuit of efficiency. As one commercial judge recently put it, if you want to roll up to the commercial court in a Mini, we won't always insist you pimp it up into a Rolls Royce. The Scots procedure for disclosure compares favourably to that in many other jurisdictions. The system avoids time-consuming and expensive processes. The scope for disclosure is generally restricted to documents or other materials which are demonstrably relevant to the case. It encourages voluntary production, but is backed up by the court's powers to order production of particular documents or things under a controlled process which requires a reasonable amount of specification of what is sought and the reasons for its recovery. In the commercial court, this will occur during the case management stage. Put shortly, the use of discovery as a weapon of mass destruction is firmly discouraged. The facilitation of quick appellate decisions is an attraction which we seek to promote even under the current physical distancing rules. The introduction of the Intermediate Sheriff Appeal Court substantially reduced the burden on the appellate divisions of the Court of Session. They allow that court to focus on the most important cases and to improve its expedition and efficiency. Appeals from the Commercial Court are heard by 3 judges, the court almost always chaired either by myself or the Lord Justice Clerk, who is Lady Dorian, Scotland's second most senior judge. And we sit with 2 other judges with experience in these types of case. There is a willingness also to grant urgent disposal in appeals to respond to particular commercial exigencies as they arise. The Court of Session practice note on the conduct of commercial actions places a keen emphasis on alternative dispute resolution. At all key stages, the parties are expected to give this due consideration. ADR has become a particular policy focus of the Scottish Parliament's Justice Committee. Last year, it published its report entitled "I Won't See You in Court: Alternative Dispute Resolution in Scotland." It emphasised the committee's favouring of increased use of ADR. There is a unity of purpose in this respect. ADR in Scotland, as in all jurisdictions, is conducted within the long shadow of the courtroom. The court remains the ultimate compulsator in all forms of a dispute resolution. The court and ADR must thus be viewed not as in competition with one another, but as part of a complementary system, working as a whole to provide an efficient, modern, and suitably sophisticated civil justice system that can readily be seen as attractive to litigants and to the legal profession. Like the Commercial Court, the Scottish Arbitration Centre is a neutral, affordable, English-speaking venue for domestic and international arbitration. The Faculty of Advocates, which is the Scottish Referral Bar, has its own ADR service. It offers a special group of Scottish counsel seeking to support and improve arbitration opportunities. The Law Society of Scotland, which is the umbrella organisation for the solicitor branch of the profession, has a similar service, as does the Scottish Arbitration Centre, the Chartered Institute of Arbiters, and the Royal Institute of Chartered Surveyors. Arbitration has been an increasingly important part of Scottish civil justice since the enactment of the Scottish Arbitration Act in 2010. Structurally, the Act is user-friendly, separating law from procedure. Rules are placed in a schedule and divided into the categories of mandatory and default. Based on the model law principles, the New York Convention, and what were assessed to be the favourable features of the pre-devolution Scottish Act of 1996, the new Act was the product of extensive research into arbitral law and procedures, with the aim of placing Scotland in the vanguard of best international practice. Innovations included an answer to the question of the law applicable to the arbitration agreement, which recently divided the justices of the UK Supreme Court. Spoiler alert, the answer in Scots law is that if the parties agree that an arbitration is to be seated in Scotland, then the arbitration agreement is to be governed by Scots law, unless otherwise specified or agreed. Other features are arbitral appointments referees and anonymity if the matter reaches the court. The product is a modern and innovative regime. It has resulted in growth in the use of arbitration in commercial matters, construction and renewable energy cases, and consumer employment and partnership disputes. Outside of the Act itself, the training of Scots lawyers who bring together the Roman, that is to say the European, and Anglo-American legal worlds, ought to be a competitive advantage in the international marketplace. The courts are keen to see Scottish arbitration thrive. Judges played a key role in the development of the 2010 Act. At any one time, there is a nominated arbitration judge who hears court proceedings brought under the 2010 Act. The early jurisprudence interpreting the Act has been widely applauded by the arbitration community. In 2017, the Scottish Arbitration Centre collaborated with the commercial judges in the Court of Session to establish the Arbitration Court Users Group. Like the Scottish Civil Justice Council, it provides a forum for consultation, discussion, and feedback amongst judges, legal practitioners, and court officials, specifically on arbitration matters that from time to time come before the court. It focuses on practice and procedure and is well placed to offer authoritative views on the operation and effectiveness of the 2010 Act. I conclude. The Scottish system of civil justice now has a responsive institutional framework within which to improve the delivery of civil justice. It recognises that it ought to promote proportionality and choice in terms of which process suits parties best. ADR is a key part of the system, but the courts in all circumstances must be accessible to all parties in order to secure the enforcement of legal rights and duties, including agreements to pursue arbitration or other forms of ADR. The courts must strive to provide high-quality decisions in a quick and cost-effective manner to ensure that the selection of a form of alternative process is a choice based on the positives of that process rather than the negatives of litigation. Finally, I look forward to meeting you all in person at the Congress next year. Thank you all for listening so attentively. It is much appreciated.
Thank you, Lord President, for that excellent overview of dispute resolution here in Scotland, with a focus on the approach of our courts. Just a reminder to those who've joined us, so there's around 100 of you out there, I understand. If you have any questions, please put those questions in the Q&A box. Please also let us know that you're there on the chat box, where you're from. It would be good to know what you think. Okay, next it's Brandon Malone. Brandon is the chairman of the board of the Scottish Arbitration Centre. He is a solicitor advocate in Scotland and a solicitor of the senior courts in England and Wales. Brandon is also an arbitrator, adjudicator and mediator. He is a member of the ICC Commission on Arbitration and ADR. He chairs the ICCA New York City Bar CPR Institute Working Group on Cyber Security in International Arbitration. And of course, in September 2021, Brandon will chair ICCA Edinburgh. Brandon's going to talk in some more detail about alternatives to litigation in Scotland, with a particular focus on arbitration system. Brandon.
Thank you, Andrew, for that introduction, and to our other speakers. It's wonderful to have so many people here on a Friday evening listening to us. I'll try and make this worthy of a Friday evening's entertainment. So, alternative dispute resolution in Scotland. I am going to focus on arbitration, as you might expect, but we do have other forms regularly used in Scotland. Mediation, for example, is used very often. Adjudication, expert determination. I'll touch on dispute boards and then talk a bit more detail about arbitration. So, mediation. Mediation, I think it's fair to say, is now very well established and developed in Scotland. It is completely voluntary, so there are no sanctions for failing to use mediation in expenses or in any other way, unlike in some other jurisdictions. It's very popular for family law. I think it's gaining traction in commercial cases. Proceedings are confidential and privileged so long as the mediation agreement provides for that. Settlement agreements can be enforced through the courts in a normal way as an ordinary contract. Scotland, well, the UK, and therefore Scotland, is not yet a signatory to the Singapore Convention, so they can't be enforced directly yet. I'm not sure if that's going to happen in the future, we'll see. And there is strong Scottish Government support for the development of mediation. We see that across a number of projects. So I expect mediation to continue to grow. I probably have to confess that I was once upon a time a mediation skeptic, but I have recently, even myself, become a mediator for the RICS and IMI. So I'm a convert as well. Now, adjudication I want to talk about briefly. Adjudication is basically focused on construction, operation contracts. It's a rapid 28-day process which produces a temporarily binding decision. It's available as a matter of statute in Scotland in respect of contracts for construction operations, but it can also be entered into voluntarily for other types of contracts if parties desire, and it's suitable for resolving long-term projects, disputes on long-term projects, to allow them to continue to produce a temporary decision. The courts are very supportive of adjudication, and it is very difficult to challenge an adjudicator's award. It would be fair to say that construction adjudication is very popular and has basically become the default choice in that sector, although arbitration is gaining a little ground. Expert determination, it's also now very well established and well understood in Scotland. It offers a rapid binding dispute resolution procedure. The expert, in contrast to an adjudicator, an arbitrator, or judge for that matter, is not bound by the rules of natural justice in the same way. It's a very useful process where the issue at stake is one of quantity or degree or quality or value. In other words, a dispute where an opinion can determine the issue. It's very often used in property disputes and certain other categories where the opinion of an expert is going to determine the issue. Parties may be entirely agreed on the law that applies, but simply can't agree on that opinion issue, and that's where expert determination helps. It's extremely difficult to challenge an expert determination, since it's normally a matter of opinion, and an expert's opinion is an expert's opinion and cannot therefore be wrong as such. Now, dispute boards is another method that's gaining some traction in Scotland. Whether that's dispute resolution boards or dispute advisory boards, they, of course, are only really used on major projects. I know that there was one used on the Forth Crossing, for example, the new bridge. They are a little more expensive because, of course, you have to have the board in place throughout the life of the project, but there's evidence that they do create savings in the long term, and they're very popular in other jurisdictions, United States, for example. And we do see increased activity of the Dispute Resolution Board Foundation, for example. And the idea there is they either provide a temporarily binding decision on a dispute over the course of a project to allow it to continue, or they simply provide an advisory opinion, and that depends on the type of contract that's been set up. And then everything is swept up at the end. But of course, as with adjudication, it's common for parties simply to accept the temporary decision that was arrived at during the contract. So I now look at arbitration. And I want to look at arbitration through the prism of the London Centenary principles that were put together by the Chartered Institute of Arbitrators, and look at Scotland's suitability as a seat in that context. So the first criterion is the law. And as we've already heard from the Lord President, we have in Scotland a modern arbitration law. It will be instantly familiar to those who know the Arbitration Act 1996, which applies in England and Wales. It's very similar, almost to the point of being identical in some respects. And even our courts have said, our judges have said that the cases which have been decided under the English Act, whilst not binding on the Scottish courts, are certainly going to be very useful and informative in guiding how the Scottish Act is to be interpreted. There are certainly a number of improvements on the Act and innovations, and Lord Carloway referred to those, but there's nothing that would shock or confuse. Court intervention is limited but very supportive, and there are limited opportunities for challenge of an award. We have opt-out confidentiality, which is the choice favoured by corporate counsel. We'll talk a bit more about that. There are various exceptions, of course, to the confidentiality provision, but it is the default position. So parties can opt out, decide they don't want confidentiality, and for example, you'd probably do that in investor-state arbitration to allow transparency. But for those that want it, we have a very effective system. It applies to the parties and to the tribunal, and a breach of that duty is actionable. There's a presumption of anonymity for applications to the court arising out of any arbitration under the Act. Parties are anonymised. It's not a public process. It's a closed-door process. And we've seen a number, if you want to look at the court reports, you can see a number of examples of how this works in practice. So we had arbitration application number 2 of 2011, very exciting case name there, but you can see even the names of the parties are anonymised. And in that case, the judge, Lord Glennie, went so far as to allow the parties to see his opinion in draft, to let them comment as to whether there was anything within that opinion that was going to divulge the identity of the parties, and even invited them, if they saw fit, to make representations that no opinion should be published whatsoever. So you can see that the Scottish courts are very supportive of the spirit and the letter of the anonymity and confidentiality regime. The next criterion that the London Centenary Principles puts up is the legal expertise. Now, Now, many of the large international firms have bases in Scotland, so there's a lot of choice. We have Clyde & Co, for example, CMS, Denton's, Pinson Masons, big international firms have offices here. But also we have the big Scottish firms like Brodie's and Burness Paul and Shepard & Wedderburn. They've got expertise in international arbitration. And of course, we have the odd boutique. So, education, this was the next criterion on the London Centenary Principles. And what is desired there, that there is an implemented commitment to the education of counsel, arbitrators, the judiciary, experts, users and students of the character and autonomy of international arbitration, and to the further development of learning in the field of arbitration. There has been a proliferation of international arbitration events, particularly since we secured the ICCA Congress back in 2016. There seems to be 2, 3, 4 major events in Scotland on this topic every year, and countless seminars and webinars. Our universities are all now teaching international dispute resolution, and we also had the judicial training that Lord Carloway referred to earlier. Rights of representation. This is always an interesting topic, and I see developments in India, actually, I think today. But certainly Scotland is and has always been an open jurisdiction for arbitration. There are no restrictions on party representation in an arbitration seated in Scotland. You don't have to be a Scottish lawyer. You don't have to be a lawyer at all. So entirely open for arbitration purposes, and that of course also applies to arbitrators. Accessibility and safety was the next one. We have good links in Scotland, good travel links, perhaps not quite as good as they are at the moment with the COVID restrictions, but we have direct flights from Scotland to over 150 destinations worldwide, including all the major destinations in Europe, the United States and the Middle East. And Edinburgh, in terms of safety and desirability, Edinburgh consistently ranks among the best cities to live in the world. Facilities is another criterion. Now facilities are perhaps less crucial at the moment, given the pandemic and the rise of virtual hearings. But even with our physical hearings, we have various venues here capable of hosting international arbitration hearings, including iconic legal venues such as the Signet Library and the University and major hotels. And of course, the Arbitration Centre is also available for perhaps not the biggest of international arbitrations, but we can take a fair few people. In terms of support for that process, the major IT and translation companies are very happy to operate in Scotland and will provide the necessary tech and backup for international hearings. Ethics is another very important aspect of a seat, and the Scottish legal professions have always been outward looking, embracing, as we've heard, both the civil and common law traditions. Scotland's Bar, the Faculty of Advocates, dates from 1532 and perhaps before that. The Society of Writers to Her Majesty's Signet, a grouping of solicitors, has over 500 years of history and is the oldest extant professional body in the world. So it's fair to say the Scottish professions uphold the very highest ethical standards. Now, what about enforceability? And what's desired here is adherence to international treaties and agreements governing and impacting the ready recognition and enforcement of foreign arbitration agreements, orders and awards made at the seat in other countries, at a seat in other countries. Scotland remains part of the UK, at least at the moment, and as a result is party to many international agreements, including, of course, the New York Convention. The Arbitration Scotland Act provides for the ready recognition and enforcement of awards made in other countries here in Scotland. And the rule of law certainly holds sway in Scotland, I'm happy to confirm. Immunity, obviously a very important consideration. There's a mandatory rule within the Act that the tribunal and any arbitrator, including the clerks, staff and tribunal secretaries, are not liable for any act or omission unless there's bad faith. Arbitral institutions are not liable for any act or omission in the exercise of their function, again, unless there has been bad faith, and are not liable for the acts and omissions of arbitrators. And expert witnesses have the same immunity as they would enjoy in court. So, in conclusion, Scotland has a thriving alternative dispute resolution scene. Scotland ticks all of the boxes as a safe seat of arbitration. Now, of course, many places tick all of those boxes, but nowhere else is Scotland, nowhere else is Edinburgh. And I can't wait to welcome all of you to the ICCA Congress in September 2021. Thank you.
Thanks very much to Brandon. Okay, we have a bit of time for some of your questions now. I hope the panel can also see those questions. But I think I'll start with David Hossack, who's asked about the term alternative dispute resolution. What do the panel think about the use of this? It's quite often criticised as a term. David suggesting that maybe the word alternative should be deleted. Lucy, do you have a view on that?
Well, I don't know how realistic that is. I think probably a more realistic suggestion would be to start using the proper word litigation for the traditional national court or local court dispute resolution, and have arbitration, mediation, and other options set out with their proper names. I couldn't agree more, by the way, though, that ADR is misunderstood and abused in usage. Alternative to what? Fair enough.
Okay, Brandon, do you have a view on that?
Yes, I mean, it's an interesting question. I do a lecture every year on dispute resolution on a master's at Strathclyde, and that's always the first thing I talk about: alternative dispute resolution. Alternative to what? Is it alternative to the traditional? Do you mean litigation by traditional? Of course, arbitration has a history as long as, and probably longer than litigation. So it's confusing, and it's probably not helpful. And I think I agree with Lucy entirely. It's best to talk about mediation, arbitration, litigation, and call them what they are. I think people conflate the term ADR and mediation, and of course that's confusing for people because ADR is commonly understood to mean arbitration, expert determination, and other things as well. So I would agree, but I would also share Lucy's view that it's going to be difficult to stamp the term out. It's very well established right across the world, so I don't know how we get rid of it. But I think by saying what we mean is probably the best way to do it. Okay,
Lord Carloway, do you want to chip in?
Well, I think I agree with the last two comments. The problem is that it's so well established that it would take quite a lot of effort to change the terminology. And of course, the danger is when you change the terminology, you choose terminology which is even more confusing. So I think probably, although the point is well made, the term is probably here to stay for some time.
Okay, the next, I'll just put this to Lord Carloway, I think. Peter Scott Caldwell says that you mentioned that discovery was limited in the Scottish courts. Are the Scottish courts more generous in allowing discovery than under the IBA rules of evidence?
I think that the general approach here is that if you want discovery of things, then you will have to ask for it and justify it, rather than just there being a sort of general discovery. We've for many years tried to avoid the situation in which parties, whichever side they happen to be on, simply dump thousands of documents on people and expect them to sift through them. There are elements of that here from time to time, but the general objective is to restrict discovery and try to persuade parties just to provide what is really being asked for. And so the answer to the question is, I think discovery is more restrictive, but not in the sense of you not being able to get what you want.
Yeah.
It just stops the peripheral stuff.
Okay, thanks, Lord Carloway. And Peter, who's into tomorrow, where he is in Hong Kong. Brandon, here's one for you. It's from Graham Boyack at Scottish Mediation. Do you think there should be a Scottish Mediation Act, given your newfound love for media?
Yes, I mean, I think there ought to be. I think there are aspects. Well, I think it would help in promotion understanding of it. I mean, I think we want to look at the implementation of settlement agreements that arise under mediation, if that can be assisted. I mean, I suppose it depends what you want in a mediation act, and you know, do you mean that there ought to be compulsory mediation in some areas, which I see is another question that's been asked. That's an interesting question. Should you ought to, or perhaps one step back from that, should you, and this is something we've argued for a long time, since actually I know there was a discussion about this even before the Arbitration Centre was set up, having some sort of triage so that when a dispute arises, people are formally presented with their options and encouraged to think about it before they push on with the court action. And that's something the kind of thing that could go in a mediation act, perhaps. Of course, these things require funding and there's a cost attached to them. But in principle, yes, I mean, I think mediation is much better understood now, is coming of age. And I know there is a mediation bill out there. I don't really think it's a draft act as such, but I know there's a lot of movement towards trying to enshrine mediation's place in Scottish dispute resolution, and I'd be in favour of that.
Okay, thanks for that, Brandon. We're rapidly running out of time. There is a question maybe for you, Lucy. I don't know if you can see it at the bottom, which is about a COVID-related question, and what is ICCA doing in terms of dealing with e-bundles and remote hearings. So I think you mentioned some of this earlier, but do you just want to come in on that?
Yes, there have been a number of webinars and programs on how virtual hearings are being done and protocols for them, which we're all watching. The one thing that ICCA is doing specifically is, at the suggestion of a couple of practitioners and academics, we're supporting this comparative research project, as I mentioned, on the legal questions of whether there is a right to have a physical in-person hearing. In many jurisdictions, there is in Switzerland, by the way, which means that there has to be postponements if the parties don't agree to a virtual hearing. There are other jurisdictions that specifically allow for virtual hearings, even if the parties don't agree. So ICCA is supporting collecting all of that data and looking also at litigation and looking to be able to give commentary, I would say, commentary for the benefit of counsel and arbitrators in all the permutations of parties wanting virtual hearings, not wanting virtual hearings. And that should come out, we hope, begin to come out by the end of the year. We don't run arbitrations, so we're not preparing any protocols or any practical information per se.
Okay, thanks for that, Lucy. Just following on from that, Brandon, there's a question about online dispute resolution and artificial intelligence, and some concerns about that. Do you want to say something very briefly on that as a sort of follow-up?
Yes, well, it's a fascinating area. I mean, I don't know if anyone managed to see the Alexander lecture last night, the Chartered Institute put on. Richard Susskind gave a talk on this very topic, and it was absolutely fascinating. And I see the question is, you know, with ODR, we don't know what is happening inside the black box, the algorithms and what have you. And Richard made the interesting point. Well, we don't know what's happening inside the black box of a judge's brain. and how is that all coming together, and what's affecting, and to an extent, of course, they're giving reasons, but what's behind the reasons. So, I mean, I think technology is moving at a rate which is really quite frightening. As Richard put it, we're at the knee of the curve, because things are about to, if we think we're technologically advanced at the moment, things are really about to take off with blockchain and smart contracts, but also quantum computing, and the increase in computing power that quantum computing, which Google claimed and NASA claimed to have now achieved, is going to increase computing power exponentially, to an extent which is really quite almost impossible to comprehend the difference in speed. And I don't have the numbers right in front of me, but there's a calculation that this quantum computer has been able to do that would take even the fastest supercomputer at the moment something like 10,000 years to achieve. So if you think of that difference in computing power and try to think how that's going to be brought to bear on current artificial intelligence, it's really quite terrifying how quickly computer power is going to move on. But the other side of that coin is, at the moment, and it's to do with access to justice, because justice, we know, is so expensive to get. And if you look at Brazil and India and the delays in cases there, where you've got a backlog running to tens of millions of cases. If you've got a choice between waiting hundreds of years for the outcome of your case or letting an AI determine it and getting a result, because justice delayed is justice denied. So there are all kinds of really interesting questions that arise out of this, and things are moving at an exponential rate. I don't think we're going to see anything in the very short term, certainly 5 years. But when we look ahead 20 years, anybody that claims to be able to predict 20 years from now in terms of technology and law, they can't. So it's a difficult question, and I see the concerns are justified, but we're just going to have to continue to work with it and play it by ear as we go along.
Okay, I'm really not sure we have time for much more. I'm tempted to put this to you, though, Lord President. How will Scots law be affected by Brexit? But you've got 30 seconds to answer it. You're on mute, so.
Maybe keeping himself on mute on purpose.
Yeah, I don't know the answer to this, because we don't know what, if any, deal there is going to be made. So until we get that information, it's impossible to second guess. It's more interesting to know what the reactions of the people will be.
Thank you for that. Thank you for that. Okay, well, I think we didn't quite get through all the questions, but thank you for those questions that came in. I think that was very interesting. Thanks to the panel. I appreciate it's for some of us a Friday night, and giving up your time is very much appreciated by Centre. We have to go because the First Minister is up next, and we don't want to miss that, and we don't want you to miss that. So please do find the link on the IBA website to see what our First Minister has to say over the course of the next hour. Please also, if you haven't already registered, please do register for ICCA Edinburgh next year. There's details online about that, and we'll open registration very soon. We're going to play you a promotional video now for ICCA Edinburgh to get you in the mood for next year, when we're sure it will actually happen. Thanks again to everyone who joined us, and goodbye from us.
Scotland is immensely proud of its long history of arbitration, spanning some 700 years. The Arbitration Scotland Act 2010 has enabled us to have one of the most modern systems of arbitration in the world. I consider arbitration to form part of our business-friendly environment. Furthermore, the Scottish legal system is held in high regard. With its continental roots and common law influences, it has contributed to international principles of law.
As a legal jurisdiction, Scotland has a mixed system, much in the way that international arbitration might be described, with common and civil law influences. An example of this is our restricted approach to document discovery, in contrast to our English neighbours. Scotland is an open jurisdiction, and there are no limits on who may appear as counsel in an arbitration or as an arbitrator. The Scottish courts have adopted a supportive but non-interventionist approach to arbitration under the Arbitration Scotland Act 2010. Appeals against awards, and indeed any court involvement in an arbitration, are dealt with by a streamlined process under the specific court rules related to the Act. Applications are dealt with by specialist arbitration judges appointed by the court. Parties' names are anonymised on request, and related proceedings take place in closed court. Last year, the court established an arbitration court users group to provide a forum for consultation, discussion and feedback between judges, legal professionals and others involved in arbitration matters in Scottish courts. All of this illustrates Scotland's continuing commitment to ensuring that it has a strong arbitration system to offer to the world.
Scotland is one of Europe's ancient nations, and arbitration has been practiced here for many centuries. It has been a familiar part of our legal culture since the Middle Ages and has always had an international outlook. However, in terms of modern international arbitration regime, Scotland is very much an emerging nation. We are an independent arbitral jurisdiction, and if we were an independent nation, we would have the 15th largest economy in Europe, with a GDP of $228 billion a year. Our economy is diverse. We are a major financial centre, a centre of biotechnology, computing and video game technology. And of course, we're a centre of energy production, both in oil and gas and renewables. In 2020, as well as hosting the ICCA Congress, we'll be celebrating the 10th anniversary of the Scottish Arbitration Act, which provides a modern and easily understood framework for international arbitration. We do hope very much that you will join us for these celebrations.
Making connections delivers results, and there is no doubt in my mind that the Scottish Arbitration Centre is spreading Scotland's arbitration message more widely than ever before. Edinburgh, our capital city, is ideally placed to host the ICCA 2020 Congress, with the facilities and professionalism available in the city acknowledged by the meetings industry worldwide. I know that all the partners in Edinburgh will work to ensure delegates are given every assistance to make the most of their visit to Scotland, and that all your delegates will experience the heritage, the culture and the activities that can be found throughout our country.
Now is the time to look to Scotland.